Welcome to Learning with Dr. Shivangi. Today's topic is conditions for lifting the corporate veil. As in the previous videos, we already started the playlist for the subject company law and also discusses various topics related to it like uh, provisions, various important provisions of company law, administration of company law, and so on. So in today's video we'll discuss about this topic. You can also watch other videos, links are provided in the description box. So before I started the video, I want to say you that if you like my video, please like and share this video, and don't forget to subscribe my channel, which is Learning with Dr. Shivangi. Now coming to the main topic, which is conditions for lifting the corporate veil. Corporate veil is a very important topic related to Companies Act, as we will discuss here. So firstly we have to understand about the what is company, or what is the meaning of company according to the Companies Act. So a company is an artificial person which is born by the act of law, functions as per provisions of law, and is terminated by an act of law. So company is generated or um, prepared, made by the under the government of India or the Companies Act, different rules and provisions also, and it can also be terminated by the law, or we can say that Companies Act. If there is any person who is the owner or the shareholder of the company or the partner of the company, if there is death or injury or insolvency of that particular person, company is not related to that particular person's death or any other term and conditions. The company's identity is totally different from that of its members. The company is in no way affected by the death, insolvency, or lunacy of its members, or nor it is affected by the members leaving the company or others joining it. So the members of the companies may be changed in future, or the shareholders may become changed in future. The company remains itself. So there is a difference between the identity and the identity of company and the members of the companies also. It is not affected by the members of the company. An increase in the number of members likewise has no effect on the company. All affairs of the company are managed by its board of directors, who are the nominees of its shareholders. So companies managed by the board of directors, who are also the nominees of the shareholders in the company. The company is liable for all actions of the board which are beyond the declared objectives of the company, or which infringe the limits of law or right. So company is managed by the board of directors, who are also the nominees of the shareholders, and the company is liable for all the relative actions of the board of directors within the objectives of the company, or which can't infringe the objectives or laws of the company itself. Although the company is an association of members who have an interest in its assets, the moment it is incorporated, it assumes a separate identity than that of its members. The verdict in this case of Solomon versus Solomon and Company Limited is an important illustration of the separate legal entity of the company. So the company has a separate legal entity beyond its members of the company. It is not related to the insolvency, death, or any other incident with the members of the company itself. The Solomon was the trader in shoes who formed a company named Solomon and Company, of which he, his wife, daughter, and 4 sons were the member of the company. He sold his business to the company for $30,000, in consideration of which the company allotted him 2 lakhs worth of shares and 10,000 worth of debentures, and $7,000 of the unsecured creditors. The creditors put up the claim that since Solomon and Company were the same entity, unsecured creditors should get priority over the debenture holder, who was Solomon himself. It was held that Solomon and Company were two separate entities, and the debenture holder should have the priority in the payment. As the company has the separate legal entity, so the debenture holder, the shareholder, has its own identity, so he should be prioritized in the payment of the shareholders. The verdict in the case of Solomon versus Solomon and Company established the fact that there crops up the veil between a company and its members when it is incorporated, which lawfully gives a separate entity to the company and its members also. This distinction between the two or the whale, it is commonly referred to the corporate will of the company. The company, being an artificial person, does not perform any function by itself. Its functions are performed by the directors of the company. So the company and the members of the company has its own separate entity. They are not connected to each other. All the functions are performed by the board of directors of the company. The company is the artificial person. He can't perform any function by itself. It is performed by the board of directors. So the shareholders or the debentures holder should be prioritized in the payment of the shares of the company. As in the case of Solomon and Solomon Limited. If the directors of the company defraud the company or any third party or do an act which goes against the company's act, the law permits on the order of the court to lift the corporate veil and make the directors or members guilty of misconduct and face of wrath of law. In situations when, under the provisions of law and recognizing the separate legal entity of the company, the court directs the lifting the corporate veil and hold the directors or functionaries of the companies liable for their actions. It is carried piercing the corporate veil. So when the company is governed by board of directors, so all the functions are performed by the board of directors. So for the any functions of the company, board of directors are liable for the actions of the company according to the code. So it is known as the piercing the corporate veil. According to Professor Grover, where the law disregards the corporate entity and pays regard instead of the individual members behind the legal facade, it is known as the lifting the veil of corporate personality or the lifting the corporate veil. So there are two conditions of lifting the corporate veil of the company, which are under the statutory provisions and under the judicial interpretations. So these are the two conditions for lifting the corporate veil of the company. So this is all about the conditions for lifting the corporate veil of the company. I again summarizes all the points so that you can easily understand about the topic. So what is conditions for lifting the corporate veil of the company? Company has its own separate legal identity. It is not connected with the members of the company. The functions of the companies are performed by the board of directors of the company. So they are also liable for the Companies Act or company's functions, as in the case of Solomon and Solomon Limited. As a person is not connected to the company, so he should be prioritized in the payment of the shares through the particular person. And the company has it is also known as the corporate veil. And as the person is not liable and the board of directors are liable for the functions of the company, it is known as piercing the corporate veil. There are two conditions for lifting the corporate veil, which are statutory provisions of the companies, and the second is under judicial interpretation of the companies. So this is all about the conditions for lifting the corporate veil according to the Companies Act. If you have any query about this topic, or if you want to know about any other topic related to research methodology, business legislation, companies law or business management, you can ask through comment box. If you like my video, please like and share this video, and don't forget to subscribe my channel, which is Learning with Dr. Shivangi. We'll meet in the next video with new topic. Thank you everyone.